Hi, I'm attorney Gregory Dell, joined by attorney Rachel Alters, and we're going to discuss one of Rachel's resolved cases against Aetna, which is now Hartford Disability Insurance Company. And Rachel, in these cases, in these videos, as you know, we discuss the background of the case, what the policy language was, why the claimant was denied, and how you were able to help them, and then also provide some tips for people who have Hartford/Aetna disability claims that will help them in the future with their disability claims. So tell us a little bit about the background of your claim.
This is a claimant who was the executive director of a trust for a large bank, and he suffered from a severe case of Meniere's disease that he had ongoing for multiple years. He was diagnosed back in 2006. He had a few surgeries. Nothing was very helpful. He fought through it for many years, but unfortunately the disease was progressive. And Meniere's is a disease of the inner ear. What it does is it causes severe vertigo, imbalance issues, cognitive issues, and he just couldn't focus on his job. He had a very high-level executive position, and he needed to be on the ball at all times, and the Meniere's really was getting in the way of that, and he really needed to stop working, probably years before he did, but he plowed through it because his job meant a lot to him. So he applied for the benefits, and Aetna decided that they didn't want to approve the benefits, that the Meniere's wasn't severe enough, that it was, you know, if he was able to work for all these years, why couldn't he work with it now? So they denied his claim, and we had to file an appeal on his behalf.
So that's kind of like, this is one of those, there's no sympathy, you don't get any credit for being a good guy or a good person per se by trying to work through your condition. What they do is they hold it against you and say, like you just said, like, yeah, there was no doubt he had the condition. So diagnosis was not an issue. Had multiple surgeries already for this condition, which is really not the norm for people with Meniere's. A lot of people don't necessarily get surgery. He did. Really, there is objective evidence that you have Meniere's. It was clear that he did, so there was no question about that. But then they're like, oh, but you work through it. And then also with Meniere's, especially when you have a high-level executive who you're representing, is that there's also episodic. It's episodic, sometimes not controllable, and there's attacks that come. What was happening with your client, I'm sure, is that he had been with his employer for so long, is that they were accommodating him as well. And so if he had to be out for a day, 2 or 3 days, because I have many clients who've had Meniere's, they get laid up for days at a time. Can't even go out of a room, has to be complete darkness, completely incapacitated. So this was a horrible denial. And I remember when you first got it and we talked about it, and I said, this is terrible. Like, who looked at this? So who did look at this and made this ridiculous decision? What happened? What was the basis for their denial?
Right. Well, Aetna, now Hartford, you know, they hire their peer review doctors, and they, you know, they hire their ENTs, and they review the records. They never examined him. They never actually even spoke to my client. All they did was review medical records from his doctors, and in their opinion, they said, well, there wasn't any documentation in there, and the restrictions and limitations weren't severe enough to prevent him from being able to do his job. So in their opinion, they just disagreed with his doctors. His doctors were adamant that he shouldn't be working. They said, this, you know, you should have stopped working years ago. You know, we've advised that you stop working because he had so much cognitive impairment due to the Meniere's, because the inability to focus when you are so dizzy. He was falling, you know, he couldn't concentrate on, you know, not even just the smallest task. So his doctors were very adamant in the records. The records were clear. But Hartford's doctors disagreed completely. They ignored what his doctors were saying, and they just said, well, it's our opinion that he's fine. He worked before. He's been working up to now. What are the reasons why he can't continue? So they did just a peer review, and they denied the claim. So we worked really closely with his doctors and hired our own vocational experts to refute what Hartford's doctors were alleging.
And what did it come down to from when your doctors looked at the file in the appeal? What do you think was the winning factor for you?
I think it really helped that we hired a vocational expert, because what he did was he took apart, you know, the job duties of our claimant. He reviewed them and looked at what his tasks were, what his responsibilities were on a daily basis. Then he reviewed all his restrictions, limitations, his medical records, basically all of his symptoms to show that there wasn't any possible way he could perform the material substantial duties of this high, you know, responsibility job, you know, as the executive director. There was no way he could handle this. And the fact that he handled it up to this point was incredible. You know, they were giving him all these accolades of how he pushed through all these symptoms and all of these issues that he was having for so long, and that, you know, any person could not go on any further. So the vocational report was very strong and helpful, and I think that helped us get the claim overturned.
And when you say we hired a vocational expert, can you talk a little bit about, you know, what is a vocational expert, and what do they do for you in this type of claim?
Right. They specialize in reviewing individuals' occupational information, knowing what the occupational data is and what type of jobs are available in certain areas, so that when an insurance carrier denies a claim and says, well, we believe that, you know, Mr. Jones could get these 3 jobs and he could, you know, be hired in these jobs and handle them, the vocational expert can review those opinions and say, well, we disagree with that because, number one, maybe these jobs don't actually exist, or number two, with these medical conditions, there is no way that this Mr. Jones could handle these jobs as they're so demanding. You know, he's got these issues, whether it's neck pain, back pain, Meniere's, whatever it is. The vocational expert is very versed in whether these people can handle these jobs, whether the jobs exist, how much the jobs would pay, and then whether, you know, they review the policies as well, and they give an opinion as to whether or not Mr. Jones or whoever it is can handle the material substantial duties of his occupation with his specific medical condition. So they review, they go on ONET, which they go on Department of Occupational Titles and review all the definitions and the jobs and the job duties, and it's, you know, they prepare a full report, which is, you know, objective evidence of, you know, the fact that this claimant can't work any longer.
Was your client ever approved for benefits?
No.
Okay. And the definition of disability was unable to perform substantial material duties of his own occupation.
His own occupation, right.
Is there a change of definition?
Yes, after 24 months, there is going to be a change as to whether he can perform any gainful occupation and earn 80% of his pre-disability income.
And have you reached that yet?
No.
So what do you do as his attorney, because I know you continue to represent him,
Sure.
to prepare for the change of definition?
We have to work with him and his doctors very closely so that we can make sure that the doctors are documenting that not only can he not do his job as an executive director, but that he's not able to do any job sitting at a desk 40 hours a week with any reasonable continuity due to his Meniere's disease and the cognitive issues he's having. He's also applying for Social Security disability at this moment, and he's in an appeal. We do think he's going to get approved for that as well.
And do you expect Hartford to challenge the claim at the change of definition?
Absolutely. It's something they're definitely going to do. He has a high benefit amount, and that usually also gives them more motivation to deny a claim after 24 months. So I think they are going to do that, but we'll be ready for them if we have to do another appeal.
And what tip would you give to someone who is on claim but has a change of definition coming up?
To be communicate with the doctors very closely, because if the doctors are not writing your restrictions and limitations so as, you know, to show that you can't do any gainful occupation. So if you have a physical job and the doctors are just saying, you know, for example, if you're a nurse and you have to lift 50 pounds on a daily basis, and the doctors are solely focusing on you can't lift, you can't bend, you can't stoop, all that stuff, when it comes to the change of definition, the insurance company is going to jump right on that and say, well, they never said they can't sit for extended periods. Right. And that becomes a problem, because if you just kind of automatically switch into that without having a history of them putting that in their records, the insurance carriers often don't buy it. So what we do is we try and work with the doctors and have them say, also, you know, not only can you not lift, but due to your back pain, your neck pain, your hip pain, whatever's going on with you, you're not able to do a sedentary job. And in the case of my client now, you know, his issues are mainly cognitive and vertigo, and, you know, his right. job is sedentary. So even though he's a high-level executive, he's mainly doing
right.
a desk job. So we have to be very, you know, specific with the doctors that they have to say. Also, you know, he can't sit at a desk 40 hours a week and, you know, do any kind of right. job and be able to earn 80% of his pre-disability income. That's another factor that weighs in heavily. Right,
so you've already contemplated in the initial appeal to say, I don't want to just win the 24 months, that if this particular client isn't going to be able to work for the foreseeable future in any occupation, then you've already set the foundation for that with all the medical records, especially when you did the appeal, which is the right. advantage of shaping the claim into the future. You don't just think about the immediate now. You talk to the client and say, do you think you're going to go back to work? if you're 55, or is this it? Are you done? And then once they say they're applying for Social Security disability, then they're not planning to go back to any work at all.
Right.
As well. And that was
Right.
the case with your client.
Right. Well, we usually also, when we prepare, for example, an attending physician statement in the ONOC stage, we will also gear it towards any gainful occupation as well. So we will say to the doctors, don't you agree that they can't do their own job, as well as perform any gainful occupation, and usually the doctors will agree with us. So we have that in the file already as some sort of evidence that they, can't do any kind of work.
Right, and a lot of people need to realize that when you talk about doing any job, it's not just doing the job. Because a lot of people could go say, yeah, I could go do the job for a couple hours, maybe 2 hours a day, maybe 10 hours a week. That's not what it's about. It's about 40 hours a week, 8 hours a day, with reasonable continuity, with maybe an hour for lunch and 2 15-minute breaks during the day.
Right.
That's the standard that should be applied. Not saying that that's how the person worked before, but that's how the insurance company looks at it. So whether that's to your advantage or disadvantage, the point is you have to be a reliable employee who can work with continuity. And if you're someone who has chronic pain, you might be there in body, but there's no way you're there in mind. And being there in body doesn't mean anything. You have to be there in mind to be able to complete the job task. And that's the big thing that the disability companies, especially Hartford, often manipulates. But yet we're able to prove and argue against that to show why they're being unreasonable and also why our claimant is in fact disabled. So if you're someone who has a Hartford short-term or long-term disability claim, no matter where you live in the country, feel free to reach out to Rachel, myself, any of our team of disability lawyers. We'd like to immediately provide you with a free phone consultation to discuss your Hartford disability claim. And no matter where you live in the country, we look forward to speaking with you soon. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process. And when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search. Plus, we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.